I've been a lawyer for 34 years, ever since I was 24 years old. And I've always done personal injury work. I'm board certified in personal injury trial law by the Texas Board of Legal Specialization. I'm very proud of the fact that I am a trial lawyer because I do help people. Every day I wake up and I go to the office and I don't dread my work at all because I know that I'm fighting the good fight. Their case is my case. Their cause is my cause. I have a passion for this work. I get a lot of satisfaction from my work because of that. I do feel like I'm helping people. I know I'm helping people.
And welcome to the Nielsen Law Firm television show. My name is Cesar Rincon, and we're here with our very, very special guest, the man himself, board-certified attorney, Mr. Eric Nielsen. Eric, how are you?
I'm doing great, Cesar. Good to see you again, my friend.
Good to see you. Thank you for being with us today. I know you've got a tremendously busy schedule, so we appreciate it. And actually, for a change, today we're filming on location, just so we can tour your offices. And we, actually, throughout the show, we'll show some clips of your amazing offices here. But today, before we get into the matter of the topics that we're going to talk about, we're going to be talking about work injuries, or at-work injuries. Tell us a little bit about yourself, about your background, and how you came to represent injured workers.
Sure. I've been a lawyer for 35 years. I grew up in Southern California. My father was a masonry contractor. Okay. I used to work with him in the summertime all the time. Went to public school my whole life, graduated from high school out in Southern California, okay, in San Diego area, Monte Vista High School. Nice. I came when I finished high school. My parents had been divorced. My mother married my stepfather here in Houston. Okay. As soon as I graduated, I moved to Houston, went to the University of Houston, and graduated from there in 1978. Okay. Went to the University of Texas Law School, graduated from there in 1982, and I've been a lawyer since 1982.
Wow.
So I've devoted my practice to representing the same type of people that I grew up with. You know, those are the people that I knew and loved, the people that go to work every single day, that have a family to raise, you know, that are good parents, good workers, good members of society. Those are the people that I represent every day.
Right. Well, and you know, I'm so glad that you're sharing that with us because, you know, one of the things, as you know, I do some motivational speaking, and I tell people, you know, who you are today is not who you were in the past, but always know what your past is. Mm-hmm. You know, when people think of a lawyer, they think of a hotshot in a suit that drives a fancy car and just kind of throws the keys at the valet driver, right? You know, that's unfortunately in some of the Hollywood shows and things like that. That's kind of the persona that some of the characters have. But you're a man of the people. You know, you weren't raised with a silver spoon. You weren't.
Not at all.
Yeah. So that's very special that you work, you know, that you represent injured workers, because actually that's what we're going to talk about today. Mm-hmm. At work injuries. You know, it's amazing as I drive around town, as I you know, live my life. I see so many accidents waiting to happen.
Right. I
mean, out in the open. Mm-hmm. And I can't even imagine what's going on behind closed doors. We'll talk about that later. But let's talk about some of the accidents that you see that workers get into that probably could have been prevented.
Oh yeah, absolutely. Every day I see the same thing. Our city is like constantly under construction, and you can tell the difference between like big companies and smaller companies, I think, because a lot of times I'll go by a construction site that's being done by a big company, and there'll be people up working high or iron workers or whatever, and you'll see that they have proper fall protection. And then you'll go to a house or a motel that's being constructed, and you'll see workers up there that are framing or putting the decking on the roof. They don't have any fall protection at all. And that is an accident waiting to happen, a fall waiting to happen, and those are the worst types of injuries that people can get. I've handled several cases where unfortunately somebody fell from 2 stories, 20 feet high, and they were killed. And there's no reason for that whatsoever except the employer's negligence and gross negligence in failing to provide protection to their workers. It's cheap, and it's required by the law, and it's been the law since the 1970s.
Wow. Yeah, it's amazing. Not so long ago, I was driving down I-10, and I'm not going to name names, but a very famous chicken restaurant, fast food restaurant that's going up, and I saw, it's crazy, I saw the worker was on a lift, and he was doing some work on the sign, and he was climbing on and off the lift onto the sign with no protection, no restraint, nothing. And then there were people working under him, same thing, no protection, nothing. It's just crazy.
Yeah.
Now, so what happens? Let's talk about at work injury, right? Some of it is covered under workers' compensation. Some of it is not. Most people don't know and don't really understand what it is. Can you elaborate a little bit, please?
Sure. So in Texas, a company is not required to have workers' compensation, but a lot of them do. So if someone is injured on the job and their company has workers' compensation, that's their sole and exclusive remedy. All they get is workers' compensation benefits, unless that person is unfortunately killed. If the person is killed, then their spouse and their children, or if they don't have a spouse and they do have children, they can make a claim for gross negligence against the company because of the death. But otherwise, if the person survives, no matter how badly they're injured, their sole remedy is workers' compensation benefits. And we can find out pretty quickly if we know the full name of the company, whether that company carries workers' compensation or not. If it does, I know board-certified workers' compensation attorneys that I would refer that case to. If the company has chosen not to have workers' comp and there's an injury, that's the type of case that I will personally handle myself. Those are called non-subscriber cases among lawyers, and because the company is a non-subscriber to the workers' compensation system. Those are the cases that I would handle. But if you're hurt at work, give me a call. Let me decide or find out for you whether the company is covered by workers' comp or not. If it is, I have board-certified workers' comp attorneys that I can refer you to. And if it's not, I'll handle that case myself.
Okay, well now, but one of the challenges in injury at work is that the employee wants to keep their job.
Sure.
Right? And they don't want to be a troublemaker. They want to just kind of like, not necessarily brush it off, or how do they say, sweep under the rug.
Right.
But there should be no retaliation. There should be nothing about that. Talk a little bit about what the rights are of that employee.
So if your company does have workers' compensation, then they cannot discriminate against you. They can't terminate you or in any way discriminate against you because you have a workers' compensation claim, or you want to bring a workers' compensation claim, or you do bring a workers' compensation claim. There's a law that says that they can't do that. If we can prove that, I mean, that's a case that I would handle, the discrimination because of filing workers' compensation. So they should not have any fear whatsoever about making a workers' compensation claim. One thing that companies with workers' comp often do, or even companies without workers' comp, they will send the employee to the company doctor. A company that I see a lot is Concentra. That company exists to work for employers, not for employees. And under the workers' compensation system, the employee has the right to go to their own doctor. So if you go to the employer's doctor, like Concentra, and they tell you, oh, you're fine, you can go back to work, and you're still hurting, go to your own doctor and get a second opinion. And if your own doctor says, no, the first doctors are not being truthful, then you stick with your own doctor, and you're going to need a workers' compensation lawyer to go and get you the benefits that you're entitled to. Wow.
Well, and it's a process. Of course, if you've been injured, call 911. If it's needed, I guess, get the medical treatment, but then go through the process.
Absolutely.
Because you want to make sure you're okay. Let's talk about what happens if, they have workers' compensation. They go to their company doctor. Everything is fine. What if they don't have workers' compensation, and perhaps they don't have insurance? What happens? Do getting medical treatment, all those things, can you help them?
Oh, absolutely. Those are the cases that I personally handle, those non-subscriber cases where the company doesn't have workers' comp. So in those cases, and I've handled many of them over the years, typical example would be somebody who is a framer, a house framer, working on the second story. He falls off. He's badly injured. He might have a traumatic brain injury. He might have fractured legs, fractured ribs, fractured arms, fractured skull even. The company doesn't have workers' compensation. If the company has money, though, they may have to pay that worker out of their own pocket. So the difference between a workers' comp case and a non-subscriber case, there's two major ones. In a workers' compensation case, you don't have to prove that the company was negligent. You only have to prove that you received an injury during the course and scope of your employment. In a non-subscriber case, you have to prove that the company was negligent. And if you can prove that, then the company doesn't have any common law defenses. Like they can't say that, you were negligent too. If you prove that they're negligent, you can recover 100% of your damages, and they're not limited. In a workers' compensation case, the damages that you can recover, the benefits that you can recover, are limited by statute. They're limited to the tables that the workers' compensation statute allows. In a non-subscriber case, there's no limit to the amount of damages that you can recover if your company has money and if you can prove negligence. Proving negligence is usually pretty easy because the reason why you got hurt is the company violated an OSHA regulation. And OSHA's been around since at least the 70s, and these companies, every single day, I see them violating OSHA. Allowing people to work above 6 feet without fall protection is a very common one.
Mm-hmm. Wow. Well, OSHA, and it's interesting. As you know, I worked for many years. Well, I guess I won't say the name of the company, but the big broadcaster, and we were a big radio company and publicly traded company. Here's an interesting thing, because just because you work for a big company doesn't mean they're actually doing things right.
Right.
It was a big radio company, publicly traded, then merges with a bigger television company, also publicly traded. They stock merger, and now we become a unit of the big company. And I was in charge of the entire production department, 7 radio stations. I was in charge of 7 studios and a handful of employees. And here's the interesting thing. When we did the merger, legal and compliance from the bigger company that bought us came and did walkthroughs. Mm-hmm. And they found unlimited number of OSHA violations that we, even as a publicly traded company, were never even trained on.
Right.
Never even trained on. I also produced their events. I produced their concerts, the big mm-hmm. festivals, right? And I was in charge of the stage and the sound and the lighting and all that stuff. I would hire the contractors to put together the show. And same thing. They came from the bigger company to look at our events division, and they found so many violations, mm-hmm. Behind the stage, in the dark, cables running out, the stages had no railing. We talked off camera right. about railing and all that stuff. It's unbelievable how... And sorry for me rambling a little bit. It's a true story. How clearly the law is spelled out, mm-hmm. and the OSHA regulations are spelled out, but how companies just literally ignore it.
Oh yeah.
Tell us about that.
So, a lot of cases that I have involve falls on a construction site. Okay. And a fall is one of the most dangerous things that can happen, mm-hmm. because anything can be injured. If you fall from a height above 6 feet, you can fracture anything, you can die, you can get a traumatic brain injury, you can be paralyzed, anything like that. So OSHA requires that the employer provide fall protection. Not just provide, but make sure that the employees are wearing the fall protection or using the fall protection if it's a different type. There's 3 ways that OSHA says the employer can prevent falls. Number 1 is they could put up nets to make sure that if somebody falls, they don't hit the ground, they land on a net. Kind of like if you're going to the circus and you see people in the trapeze and they fall off or they jump off and they land in a net. Right. Okay, they're prevented from being injured that way. They could put up guardrails to make sure that if somebody fell off or slipped off of a roof or whatever, they're not going to go to the ground. They're going to get up against the guardrail and they'll be protected. The third way, which is the most common way, is for them to wear personal fall protection system, a harness that's tied off to something that prevents them from falling more than a few feet, and they'll just stop and dangle and they won't hit the ground. Okay. I see every single day here in Houston people working on construction sites above 6 feet. They have no fall protection whatsoever. They're being exposed to a very extreme degree of risk, and it happens every day. And I don't think it's the worker. The worker doesn't want to do their job unsafely. They want to get home to their wife and children. It's not on them, it's on the employer. And OSHA puts the burden on the employer to make sure that those fall protection systems exist and are in place, and that the employee, if it's a personal fall protection system, is wearing them and using them. That's the employer's responsibility to make sure of that. But apparently these small or medium-sized employers either don't understand that or don't care. I think everybody understands that. They just don't care, because I see these workers being exposed to these injuries every single day, and it just makes me furious that there's someone who could get injured for no reason whatsoever other than the employer not doing what he's required to do by law.
Yeah, Eric, and you know what, and that's so interesting, and by the way, I love your passion, how intense you get on the topic, because you really believe that. You don't just do the job,
oh, no.
you live it, breathe it. One of the saddest things in this situation, though, is the employee doesn't know.
Right.
They're never trained on OSHA, just like I wasn't trained on OSHA.
Exactly.
Working for a major company, I took the position as production and creative director. I managed my budget, I managed everything, but they never gave me any OSHA training. And when they toured my studios that I was responsible for, they found all kinds of wires laying across that shouldn't be there. The ADA accessibility wasn't there. Power strips that were overloaded, there's a reason why they have a certain voltage rating and so forth. I just plug it in, And so I didn't know what I didn't know. And what's amazing is, employees are out there just trying to make a living.
Sure.
Most of the time, they don't even know that they're not being compliant.
And one of the reasons why they don't know is because each employer is required to have what they call a competent person. That is a person who knows what the OSHA regulations are and knows how to recognize a potential OSHA violation, knows and has the authority to remedy it. And they are also required to train their employees about, this is what OSHA requires, and we're going to do our job this way. Every job can be done safely, and if there's an accident or an injury on a construction site, that's because almost invariably it's because the employer did not train the employee properly, or the employer himself or herself might have not even known what the OSHA regulation was. And there's no excuse for that. Every employer, no matter how small, has to have a competent person who knows what the OSHA regulations are, who knows how to follow those regulations, and who has the authority to make sure that they get followed. And if somebody doesn't follow it, even though they've been trained and they just won't follow it, then they have to have the authority to terminate that person.
Yeah, even as we put together this mobile set here to film on location here, I'm conscious of making sure I'm not drawing too much power from to different outlets. It could cause a fire.
Sure.
That the extension cords are neatly marked or possibly even blocked, so you can't trip on them.
Right.
It's amazing. Now, so if somebody gets injured, they call your office. What's next?
So if someone gets injured and they call me, we will talk to them about their case, probably set up an in-person meeting between me and one of my case managers to find out exactly what the facts of the case are. If they agree to hire us as their attorney, which I hope they do, and if we can help them, we will do everything we can. if they hire us, it'll be on what's called a contingent fee. They won't owe us any money whatsoever out of their own pocket. We only get paid if we recover money for them, and it's a percentage of the amount that we recover. So as soon as they sign up with us, then we'll contact the company. We'll do an investigation of how this incident happened. Usually the company will have some sort of internal records that say, this is an incident report. This is how it happened. So we will get that incident report. We will find out immediately what OSHA regulations apply to it. We'll get all the medical records from the client, and then once the client is finished treating and they feel like they're as good as they're going to get medically, then we'll know what the value of their case is. We'll sit down with the client and say, look, this is what we think the reasonable value of your case is, or the reasonable range of values of it. If the client agrees with us, we'll go to the employer and say, look, we think this case is worth this. Are you willing to settle for that? And if they say no, then the case is going to go into litigation. Then we'll file a lawsuit, and if the employer doesn't agree with us along the way and pay us what we think is reasonable, we'll go all the way to trial and ask a jury to determine what is a reasonable value for this case in view of what the employer did and the injuries of the person.
Excellent. Now, those are cases, and we've been talking about cases where the employer was negligent in putting up the guardrail or whatever. But let's talk also about at-work injuries where a third party outside of the employer might be liable. It could be a defective blade for a landscaping company, right, or something like that. Let's talk a little bit about that.
Sure. So some people are covered by workers' compensation and they can recover those benefits. But the injury itself was actually caused by some third party. So you can recover workers' comp just because you were injured during the course and scope of your employment. It may not be your employer's fault. It could be somebody else's fault. A lot of times, say on a construction site, there's more than one company that's doing work around there. Classic example, somebody is doing some work and a truck driver from another company comes and crashes into them, either as a pedestrian or they're in a vehicle and the person gets hurt. They can recover workers' compensation from their own employer, but they can also have a claim against the person that actually caused it and the company that caused it. That's what we call a third-party claim because it was caused by a third party.
Right.
So when that happens, those are cases that I handle every single day. We would probably have the board-certified workers' compensation lawyer handle the workers' compensation part, and then we personally would handle the part against the third party. Now, in those kind of cases, the workers' compensation company has the right to get paid back every bit of the medical and the weekly workers' comp, in what we call indemnity payments for loss of wages. Right. The workers' comp company has the right to get that paid back before the employee gets anything out of it. So we try and make sure that the value of the third-party case is much larger than the value of the workers' comp claim. And we can usually get the comp claim reduced. The law says that they have to pay us up to 1/3 for attorney's fees, and the client only has to pay us one attorney's fee for the whole amount. So anything that we can reduce the workers' comp lien down to goes to the benefit of the employee,
Excellent.
Our client.
Excellent. Well, Eric, this is a fascinating topic. We could talk, for hours, for weeks
right.
about it. And one thing I was thinking about, I'll just put it out there because you said, yes, a truck might come and hit maybe scaffolding that was set up by a third-party company. They didn't put in the screws in right or whatever.
It collapses,
scaffold collapses. Or maybe even the manufacturing of the scaffolding itself.
True.
It's rated at a certain weight, and even at lesser weight than it was rated for, it still collapses or something like that. So, Eric, somebody wants to contact you. We've had the number on the screen. What do they do?
just give us a call.
Okay.
And somebody, if I'm in court or in trial, one of my attorneys will answer their call, and if I'm here, I'll answer their call.
Okay.
I'll talk to them about their case. They never have to pay us anything. They can come talk to us on the phone. They can come talk to us in person. They never have to pay us anything to talk about their case.
Okay.
If there's a way that we can help them, we will. That's our job. My job is to help people. I'm passionate about this work because I know that I'm making a difference, and this is the way that I can make a difference as an attorney in how people behave. If people are not held accountable for what they do, then they're never going to change their behavior. If a company allows people to say work without fall protection, and they're not held accountable when somebody gets injured, then what have they learned?
Right.
They learned that they can get off.
Get away with it.
Get away with it, exactly. So conduct that's rewarded is conduct that's repeated. And we want to make sure that people are held accountable. And that's how we do our little bit to change the world and make it a little bit safer for all the workers out there.
Well, we appreciate it, Eric, because somebody needs to step up and fight the good fight. So in the name of so many people who've been wronged and who unfortunately will continue to be wronged, thank you for your passion and your dedication for helping the average person through this horrible tragedies that happen, and that I know firsthand how a family can be affected. So
absolutely,
thank you so much for your passion. And for those of you watching out there, if you or somebody that you know have been injured in a car accident, 18-wheeler accident, at work accident, even at home, and we have to do another show about
Sure.
accidents in your home. Definitely call the Nielsen Law Firm, and I love the website. It's Nielsen Trial Law, because we didn't really even talk about this. We've talked about it in other shows.
Mm-hmm.
You are not afraid to go to trial. You're not afraid to go all the way to fight for what's right.
Not at all.
Yeah.
I always tell people I'm their warrior. People that are injured, they need someone to fight for them, because they can't fight for themselves against an insurance company or whatever.
Yeah.
The insurance company has all kinds of warriors that they pay all kinds of money to. So who's going to be the warrior for the person that's hurt?
Right.
I will.
Excellent. All right, Eric. Well, thank you so much.
Hey, Cesar, my
Appreciate
pleasure.
it, and we'll be talking very soon.
Thank you. I've been a lawyer for 34 years, ever since I was 24 years old. And I've always done personal injury work. I'm board certified in personal injury trial law by the Texas Board of Legal Specialization. I'm very proud of the fact that I am a trial lawyer, because I do help people. Every day I wake up and I go to the office, and I don't dread my work at all, because I know that I'm fighting the good fight. People that are injured, most of the time, could never afford a lawyer if they had to pay them by the hour. I work on a contingent fee, which means that I only get paid if I'm able to recover something for my client. We never look at our clients as potential fees. We look at our clients as people that we can help. And if we're able to help them, then we get paid. If we're not able to help them, we don't get paid, and we don't deserve to get paid. I promise you, every insurance company knows that we will go to trial, and I truly believe that the settlement offers for our clients are higher than others, because they know if they don't pay our number, they are guaranteed to get a jury trial. Their case is my case. Their cause is my cause. I have a passion for this work. I get a lot of satisfaction from my work because of that. I do feel like I'm helping people. I know I'm helping people.